Ashley Hines Walden.
Conrad Silver on behalf of Pittsfield Township.
Austin Bobasi on behalf of Ashley Hines Walden. Ms. Walden, there, could you please unmute your full name for the record?
Oh, there she
Ashley
is.
Hines Walden.
Okay, she's here. All right. What are we doing on this?
Yes, Your Honor, today's the date and time set for a pretrial. There was an offer on the table for her to clear up her license and admit to double parking. I have not been able to reach her, so I don't know where she is with that. Ms. Hines Walden, were you able to clear up your license?
Actually, so here's the problem. I am able to clear my license, but I was born in North Dakota and I didn't have my birth certificate. They're requesting my birth certificate. And so I had to send it out by the mail, and they said it'll be 7 to 10 days. But I should have everything done and cleared up because I had to pay for a reckless driving like $500. And I paid that. So everything should be cleared up if I could just have another 2-week adjournment, and I won't ask again, Your Honor. I know you've been really lenient with me, but I can't afford to get another driving while license suspended. So if you could please do that.
Boy, she just took off and went.
She covered all the bases.
I've been practicing.
You made my job easy.
It came out nothing like I practiced either, by the way. So.
Oh, I see. It came out very well, I guess. We all know she was born in North Dakota, and so you're just waiting on your birth certificate so you can go get your license.
Correct.
Okay. When did you try to get that? Do you know?
So I went, this was actually last 3 weeks ago. But it took me a week to get, I shouldn't, it was my fault. I procrastinated, but it should be in the mail right now, actually.
Yeah, we know it's your fault, but
yeah.
So I'm just trying to figure out how much time to try to give you so that you can get it done.
So honestly, if you could give me another 2 weeks, I would, everything will be set and done by then.
Who believes her? Oh, yeah, Q believes her. Oh, you believe her. Okay, Mr. So everybody's in agreement.
Well,
there you go.
4 weeks might be safer, but
yeah, that's what I'm
yeah,
thinking.
That would be safer, and but if you could do that, that would, I'm not opposed to that either. So.
Oh, so
no objections.
No, I'm the defense attorney and the prosecutor on the same case. Well, bless it.
Yeah.
Great, I was like, is he the prosecutor? The defense,
Okay, Ms. Hines Walden, here's what I'm going to do. I'm going to adjourn your case to July 19th. We'll give you time. Mail
Thank
from
you
North
so much.
Dakota is slow. At 9 a.m. Okay.
Okay. Thank you so much, Your Honor.
You're welcome.
Thank you.
Take care. On the Barrage Scott matter, and so that everything can be explained in full and everything hopefully worked out. There's a request to adjourn these matters. I will only adjourn them out to 10 days and not the 3 weeks. So I'll adjourn them to May 16th, 2023, 9 a.m. As to bond.
Your Honor, I have spoken with Mr. Scott in this matter, and we discussed the last bond violation. I don't know if the court has found out what date that was. I still don't have anything about it. But Mr. Scott believed that was when he was in the hospital and he had to walk home. So he is asking this court to put him back untethered. And he said he has been having some problems with the tether. But basically, he does believe that was when he was in the hospital.
Well, he believes that's when it was in the house when he was in the hospital, or he's sure of that. I'm looking.
He's sure. He knows he was in the hospital, but we're unsure what date the community corrections violation.
Has anybody contacted community corrections regarding its violation?
No, I have not.
Okay, so what I'm going to suggest that you do is contact community corrections ask them to give you the dates of the violations, because they're the ones that would have called it in. And then maybe, and also then where they picked up the violation, which may then fit into the sequence that Mr. Scott's giving you.
Okay,
All right. But at this time, and I've kind of set it on a short time frame because of I know you're trying to resolve things. So I'm going to deny the motion for bond reduction. His bond will continue, but he's back here real soon. And you can look into the community corrections thing, the hospitalization and the like, and tie that all up. All right.
Mr.
Thank you.
Simpson, can I say something, Mr. Simpson, please? If
I've
it's
probably
okay.
never been able to stop you, but go ahead, Barrage.
Listen, Simpson, please listen to me. Please, I know you.
I always listen to you, Barrage.
I know.
Always.
Listen, I'm asking for tether because the reason why I'm asking for tether, I don't know if you know, but my little nephew just got, he just died in Oklahoma, man, and like he got hit by a car or whatever. And my grandma said it was a good idea to put me back on tether because I was doing so good, and I'm in school now, and I have to pay these fines. I have to pay these fines off to Miss what's her name, Miss Fresh Hour, and I would like to be put on tether again. I would like to get another
Judge Fresh Hour?
Yes, I have to pay that before the 10th, or they're going to put a warrant out for me. That's the only reason why I'm asking the people, please place me back on tether. I will do good, and I have been doing good. I didn't get no violations until that time. Can you please give me one more chance today? So
Mr.
Please.
Scott? Mr. Scott?
Yes, sir.
Two things there. I'm sure that if Judge Fresh Hour knows that you were incarcerated at the time and couldn't pay the fines off, there's not going to be significant ramifications from that.
Yeah, but
That's the first thing. The second thing is that if you listen real close to what I said to counsel, and what I said is I didn't put your date out to the 25th, which I normally would have done. I put it for the 16th. So that they can try to work things out. They got to talk to you about some things so that hopefully this can all get resolved. The other thing that I just said to your attorney is to try to you told your attorney what happened that day. They need to check with community corrections, pinpoint when the violation occurred so that I'm looking at a full picture of what happened.
But do you think? Oh, yes, sir. Yes, sir.
Okay.
Yes, sir.
So then once I can see that, then I can make a decision on your request.
Well, do you think is you mad at me, or are you mad at me because like it seems like you're mad?
Mr. Scott, and am I mad at you?
I don't know. I don't want you to be.
Okay, Mr. Scott, I'm not mad at you. Usually people know if I'm mad at them.
Yeah. But
okay. And I don't know that we could have this conversation if I was mad at you. Your attorneys will tell you that.
Yes, sir. I'm just asking.
Okay.
I was just asking because if I have to pay rent and I won't have no place to stay. That's why.
Okay, Mr. Scott, listen to me.
Yes, sir.
I know all of that. The last time that you were in and I let you out, well, the last two times, you told me the same things.
I know.
In terms of a lot of it.
I know.
And I took a chance, I let you out. I'm not saying that I won't do that, but I don't have a full story of what happened.
I'll tell you what happened. This is what happened.
Okay, all right, Mr. Scott. Mr. Scott, I know you're going to tell me what happened.
Please.
I don't have a problem listening to you. But by the time you get done telling me, I'm going to be at the same spot.
I know. I just want to tell you I just want to tell you this so you understand. I went to the hospital on the 17th. I was in the hospital on 4/17.
Raj,
Yes.
I think you might want to let it go today.
So I'm not getting, can I get a PR bond or anything? If that's okay? I would really like to be out because I want another chance to be out, Mr. Simpson. Please, can you do this one last time? And I won't.
Mr. Scott.
Yes.
You said that exact thing to me the last time I let you out.
I know, but
okay, just listen, Mr. Scott. Just listen.
Okay.
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 I'm not gonna have a problem, but your attorney needs to check something
Mhm.
and try to verify what you're telling them and the court.
Okay,
Once I see that, I'm gonna make a decision. Now, I think you know about me.
I
I'll
know,
be fair with you,
I know,
and I know you know that.
I know. You were the
So,
nicest.
and you know, unless I know everything that I possibly can, I'm not making a decision.
Yeah, I know you the nicest judge in the world, so I don't got nothing to say about that.
Okay, all right. Mr. Scott,
Yes, sir.
we'll see you the 16th. They'll get the information to me, and maybe something will change, maybe it won't. But at worst, we'll see you on the 16th.
All right,
Thank you, and I'm not mad at you.
all right.
Your Honor, and I would
Okay.
ask Mr. Ganacho to just keep the offer that he made open.
In today's hearing, the court addressed two emotionally charged matters, beginning with Ashley Hines Walden, who appeared for a pretrial on a suspended license case. The prosecutor explained there had been an offer if she cleared her license, but contact had been difficult. When questioned, Ashley launched into an earnest explanation that she was fixing the issue but had been delayed because she was born in North Dakota and had no birth certificate on hand. She had mailed out the request weeks earlier and was now simply waiting for the document to arrive. She insisted she had already paid a $500 reckless driving fee and pleaded for just 2 more weeks so she wouldn't risk another DWL's charge. Her honesty surprised the room, prompting the judge to joke that she took off and covered all the bases, and after confirming both attorneys believed her, he granted an adjournment to July 19th at 9 a.m., remarking that mail from North Dakota is slow. The tone shifted when the court turned to Mr. Scott, who faced a tether violation tied to uncertain dates. His attorney explained that the violation might have occurred while he was hospitalized, but community corrections had not yet provided clarification. The judge ordered counsel to contact them, verify the exact violation date, and match it to the hospitalization timeline. A request to reinstate tether was denied for now, though the judge scheduled a rapid return date of May 16th, indicating he was willing to reconsider once the facts were confirmed. Mr. Scott then spoke directly emotional, anxious, explaining his nephew had died in Oklahoma, that his family wanted him back on tether, that he needed to work, pay fines, and avoid homelessness. He repeatedly asked whether the judge was angry with him, fearing he had disappointed the court. The judge reassured him he was not angry, but emphasized he needed a complete record before making decisions, reminding him that he had said just one more chance, the last time as well. Still, he promised fairness once the missing information arrived. The hearing closed with the judge making clear expectations. Documentation must be provided, the timeline must be verified, and until then, bond remains as set yet, the door is not closed, only paused. For more information, like and subscribe my channel.
Court calls the case, People versus Tony Bailey. 2 cases.
Alexander on behalf of the people.
And good morning, Your Honor. Gina Noveski, First Assistant Public Defender, with and on behalf of Mr. Bailey, who is present from the jail.
Good morning.
Bailey, state your name.
Tony Warren Bailey. Good morning, Judge Shelton.
Hey, well, that's okay. That's close. Good morning.
Good morning. Good morning. Good morning. Today is my
Good
daughter's birthday. She's turned 32 today. Good morning.
All right.
Remember
Good
these piranhas, Your Honor? I brought you a picture of
them. No, I don't, but they look familiar. They look like the other piranhas I'm used to seeing.
Yeah, there's 7 of them that's floating in the tank right now that I got to go home and bury.
Okay. All right. Well, let's
Can I say
see what
one
we can
more,
do.
can I say one more thing, Judge Shelton?
I haven't been able to stop you yet. Go ahead.
Well, I've been here 90 days, Your Honor, and I completed all those other cases. I got them all squashed. Like I say, today is her birthday, and I did add a couple more things to your hot rod if you'd like to see it. The car I drew you last time, there's no bullets on it.
Okay. Okay, well, first of all, let's find out what we're doing on your case. Mr.
Okay,
Noveski,
thank you. Thank you.
Your Honor,
How you doing?
hi, Mr. Bailey. Your Honor, I think what we need to do is set his matters for a preliminary exam.
All right. Then here's what I'll do. Preliminary examination will be set in person September 5th on both cases, 2023, 9 a.m. before Judge Washington. This is an old one.
Your Honor, Mr. Bailey is hoping that I address bond.
Go for it.
Thank you very much, Your Honor. Mr. Bailey has been in for 90 days, Judge. I'm sure the court's aware that there was a referral previously, but he is asking that you would allow him to be released on a personal bond at this time, especially given the amount of time he's been in. As he indicated, today is his daughter's birthday. He would very much like to be out so that he can be with his family. Unfortunately, I believe his Social Security was terminated given the amount of time that he has spent in custody. So he's going to need to get that taken care of once he is out, and perhaps, we'll be able to provide him some assistance with that through our social work department. The court's already heard that he does have his piranhas at home that need to be addressed, as well as other matters in his home regarding his utilities. So he would very much ask you to allow him to be released.
Any response?
Your Honor, at this time, we would ask that his bond remain the same until his preliminary exam. Just given the nature of this case and how it's been going, we would just ask that the bond remain the same.
I don't see how that's possible when I've been here 90 days. All my cases are.
How's his is he in touch with CMH at all?
Yes, I am.
Okay, hold on, sir.
He's
Mr. Besky, do
indicating
you
yes,
know?
Judge. I just from what he just indicated, Judge.
Okay, here's what I'm gonna do at this juncture. I'll allow it to be brought up certainly before Judge Washington at the preliminary examination, but I'm not gonna change the bond at this time until information is provided regarding his contact with CMH. So at this time, bond will continue. Motion for bond reduction at this time is denied. But you can bring it up certainly before Judge Washington. Thank you.
Your Honor, he's hoping to show you his picture today.
Okay, what picture, sir?
So your Honor, so you saying that I can't be released on tether or anything?
No, what I am indicating is,
I don't
that-
understand this. I mean.
Okay,
I've been
just
here-
listen.
I
Just
don't,
listen.
I'm okay, I'm listening, Your Honor. I've been here 90 days, all my cases.
No, I know.
I could-
And what I'm trying to, you got to listen to me. If you're not going to listen to me, I'm done.
Okay, I'm gonna listen.
What I'm indicating is I'm not opposed to releasing you. It's just I need more information about your contact and connection with community mental health.
Mental health.
And that can either be brought to me or it can be brought to Judge Washington for our consideration.
I am confused right now. I only see mental health people here in the jailhouse. They bring me pictures of art. That's it. I don't have a connection in here. Can I explain it? I don't see mental health. I have been cleared through mental health department that I am eligible to stand trial. I don't understand this part about me being slow or anything, or being retarded or anything. I don't have that problem.
Sir, that's not what I'm saying. What I'm saying is I need more information before I'm going to reduce your bond. That's the bottom line.
Mental health department through the jail? Is that what you're saying?
I've indicated it to your attorney. They'll work with you. I think they understand what I'm looking for. And so they'll talk to you about that. Okay?
Thank you, Your Honor.
Thank you.
Your Honor.
Good
Ron,
morning, Your Honor. Amy Reiser on behalf of the people.
Ron Brown appearing on behalf of the defendant in both matters, Your Honor.
All right, very good. All right. And what are we doing on these?
I'm requesting adjournment, Your Honor, both cases.
She's not here. She is not here. Lolitha Collins?
Your Honor, I talked to her twice yesterday and Monday, where I've been in constant contact with her.
We'd ask for a bench warrant, Your Honor.
Your Honor, I'm asking not for a bench warrant. I mean, I've been in contact with her.
Well, why isn't she here?
I know she works. She works and she's in school, Your Honor.
Bench warrants will issue in both matters. So if we set it 10,000 cash surety, I won't, what I'll do, give it, well, I got a child abuse third, so, and these warrants will issue immediately. I was gonna delay them, but I'm not going to in these cases. Thank you.
Thank you.
Case, People versus Shauna Webb.
Nimish Ganatra for the people.
Good afternoon, Your Honor. Raymond Burkett on behalf of Ms. Webb.
Ms. Webb, can you please?
Hi, Ms. Webb here.
Okay, what are we doing?
Your Honor, Ms. Webb understands that she has a statutory right to a preliminary examination. I've discussed this with Mr. Conatra yesterday, and we asking this honorable court to allow her to waive her preliminary examination with the understanding that she's going to be bound over to the circuit court.
That one. Yeah, there's an active bench warrant. You understand your client has a bench warrant for a failure to report or
Yes,
to
I
test
do,
at
Your
community
Honor.
corrections?
I do, Your Honor. Mr. Conatra called me last night and sent a copy over to that there was a bench warrant. However, Your Honor, then I emailed this honorable court as well as Mr. Conatra that shows that she had the case. Beg your pardon?
Yeah, that she's been testing elsewhere.
Yes, Your Honor. And on the dates that she missed here, she had tested at the other place. And I'd ask you to dismiss the warrant. Also, she can't afford to be paying both of these people what she's doing to allow her to continue to the testing.
Well, cancel the bench warrant. Defendant has to arrange to have test results sent to community corrections.
Not a problem.
Ma'am, Ms. Webb,
Yes, I'm sorry.
you understand that you're waiving your right to a preliminary examination?
I don't understand what that means exactly.
Okay, a preliminary examination is a proceeding where the people would have to show by a standard of probable cause that the offenses alleged were committed and that you committed them. You understand that?
So does
All
that
right.
mean
You would be entitled to have a hearing to show that there's probable cause that you should stand trial on these offenses. You understand that, ma'am?
Yes, I understand what that means now.
Okay. And you understand that at that hearing, the people would have to show by what the standard, the low standard of probable cause, that two things. First, that the offenses were committed and that you committed them. You understand that that's what will be happening at that hearing?
Yes,
Okay.
but I don't.
Your
agree.
counsel has indicated that you're waiving that hearing. And so you'll not have that hearing and that you'll proceed to circuit court to further resolve this case. You understand that, ma'am? That's what your attorney has said to us.
So I'm taking it to trial?
Well, you're going to circuit court to try to resolve the matter.
Okay.
You understand that?
Yeah.
Okay. Miss Webb?
Yeah, I'm sorry. I'm just overwhelmed.
All right. Ms. Webb, is that what you want to do? Or you want me to adjourn it out so you can talk with your attorney a little bit more about what you should do?
I need to talk to him.
Okay, here's what I'm going to do, Ms. Webb. All right. I'm going to adjourn the probable cause hearing. I'll adjourn it to after the holiday. So we'll do September 7th, 2023 at 9. All right. I've canceled your bench warrant. Arrange for the place that you're taking tests to send the results to community corrections. And then in all other aspects, your bond will continue
Okay, thank
at
you.
a 10,000 personal recognizance bond. All right, with the previous conditions. Okay.
Okay, thank you.
Thank you. Court does call the case of the people versus Alante Lovely.
Maria Wasinski on behalf of the people.
Really? Joy.
I'm failing at technology today. All day long. All right. Joy Gaines, Senior Assistant Public Defender, representing Miss Lovely. Miss Lovely, would you please state your name for the record?
Alante Lovely.
Okay. All right. What are we going to do on this today?
Your Honor, we've had an opportunity to speak with the prosecutor, and we all exchanged exhibits and information today. We're asking for two things. One is for the bond violation hearing to be set over to next week with Miss Lovely's hearing. The second is for her to be able to be released today. I don't believe there is an objection to either of those requests.
Is that correct on the people's part?
Yes, Your Honor.
What I'm going to do is I'll continue to preliminary examination before me on August 29, 2023 at 9 a.m. Bond violation hearing or hearing on the bond will occur at that same time on August 29 or during that proceeding. With reference to bond, Miss Lovely?
Yes, Your Honor.
So that you understand how I work. I tell people things, I tell them how I need them to conduct themselves, and then when it looks like they don't, they end up getting themselves in trouble. All right. And I think that's what, and I'm not making a finding, but I think that's what occurred in this case. And I'm just going to give you this admonishment. I'm going to give you a PR bond. I hope you've learned something from this. And I'm going to give you a PR bond. I'm going to let you out. I'm just going to let you know. I want no posting, commenting on social media regarding the case. Any social media that you are aware of that's up there, I think we've figured that part out, needs to be removed. And that includes anything having to do with the child, directly or indirectly. So if you feel a necessity to post something and you're not sure, just don't do it. Understood?
I understand.
All right. I will grant the defendant then a personal recognizance bond at this time, or reinstate her previous bond.
Thank you, Your Honor.
Thank you.
And that previous bond is with the conditions I had imposed. All right. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Is that it for us, Ms. Widley? All right, guys. Thank you, Ms. Willingring. Always a pleasure to see you.
You too, Your Honor. I think that's the first thing I
All
said
right.
today. So.
You guys have a great weekend. Allie and Marie. You guys, hold on. I just gotta know. Jack, take care of yourself, buddy. Are you guys like gonna stay around like forever?
I'm staying through the fall.
You're staying through the fall?
Yeah.
I am as well.
Hi. What?
I am as well.
Oh, so both of you will be here through the fall?
Yeah.
Oh, sweet. Okay. So I was like anticipating that time where you guys were gonna like, because Kirby never tells me anything, right? So like you guys were gonna say, it's my last day, see you, Your Honor, and then, get real sad. So I don't have to worry about that for right now. Great. Okay, you guys have a wonderful weekend.
You too,
Your Honor. Thank you.
In today's foreclosure-related docket, the court addressed multiple defendants beginning with Tony Bailey, who appeared from jail on 2 pending cases. Bailey opened with personal remarks about his daughter's birthday and even referenced the piranhas he keeps at home. Before counsel confirmed that both matters needed to be scheduled for a preliminary examination on September 5th at 9 a.m., Bailey then requested a personal recognizance bond, arguing that he had already spent 90 days in custody, lost his Social Security benefits, and needed to return home to manage urgent issues including utilities and dealing with deceased pets. However, the prosecution objected and the judge refused to modify bond until documentation of Bailey's contact with community mental health could be verified. Bailey expressed confusion and frustration, insisting he had only seen mental health workers inside the jail and had already been found competent. But the judge explained that he needed more information before considering release and instructed counsel to provide the necessary records, allowing the issue to be raised again before Judge Washington. The docket then moved to Lolita Collins, whose failure to appear resulted in the judge issuing immediate bench warrants on both of her matters due to concerns involving a child abuse third-degree charge. Next was Donna Webb, whose attorney attempted to waive her preliminary examination, but the court discovered an active bench warrant for failing to report to testing. After counsel produced evidence that Webb had been testing at another facility, the judge canceled the warrant, ordered that all future test results be sent directly to Community Corrections, and postponed the preliminary exam to September 7th, ensuring Webb had more time to understand the rights she was waiving. Finally, the court revisited Alante Lovely, whose attorneys and the prosecutor agreed to adjourn both the preliminary exam and the bond violation hearing to August 29th. The judge reinstated her PR bond but delivered a stern warning that she must completely stop posting on social media about the case or anything related to her child, emphasizing that further violations would result in immediate consequences. The session ended on a lighter note, with the judge thanking court staff for their work and expressing relief that key members would remain through the fall. For more information, like and subscribe my channel.
Court calls the case of the people versus Devon Julia Martinez.
Caitlin Kirby on behalf of the people.
Edward Drugas on behalf of Devon Martinez.
Okay, what are we doing? Mr. Martinez, state your name, please.
Devon Julia Meissner Martinez.
Your Honor, there has been a global resolution that is in the works. She was in front of you last Thursday, had matters that were bound over to circuit court. Those are going to be a part of the agreement. We're asking for an adjournment until after September 11th, which is her pretrial date up in circuit court.
During the matter of September 20th, 2023, 9 a.m. Bond continued.
No.
Thank you.
No.
And Your Honor, if I could address bond.
Go for it.
Your Honor, she's got a $5,000 cash or surety bond. It's my understanding in this case, or a 10% bond. And she's unable to post that. This is the only matter that is holding her. She does have a stable location to go to. She's provided me with an address. She is subleasing an apartment. She doesn't want to lose that sublease. And she understands that she has several cases that she's worked this agreement. And she doesn't want to blow that up by not showing up to court, and she attests that she'll show up to her next court appearance. She's got 2 matters next week.
Matters that she's pleading to on the 11th, he said?
Yes, Your Honor. My understanding, there are 3 charges that she'll be pleading to up in circuit court. And several of her cases are being dismissed.
She's got PRs on those cases?
Yeah, she's got PRs on every case.
Any response from the people?
I personally have no faith that Ms. Martinez will show up to court regardless of the outstanding global resolution that Mr. Ganatra has offered her. I would ask that her bond remain the same, and if she is to plead, this case would be dismissed and all her conditions of bond would be done on the 11th, and she would be released. So I given the history of this matter and the history that this court has with Ms. Martinez, I don't think a PR is appropriate.
May I speak, Your Honor?
If you want.
I'm sorry?
If you want to speak, you can. If it's your counsel's probably telling you not to, but
He told me. He did tell me to.
I told her to be brief.
Yes, I have an understanding that we've come to a resolution about hitting, and it's a sure thing that I will be attending court on the 11th, as the only reason that I didn't prior was because my phone was stolen, and I have since reordered my phone. It's coming 2 weeks ago, actually rather a week ago, on the 20th, on Sunday at my local Metro PCS. And aside from that, I'm trying to not get evicted from my place, and I need to go back to work. I have 2 jobs, 2 cell phones, and stable housing. And I'm really looking forward to going back to my job, and I was hoping to be released today.
I have between March of 2022 and July 19, 2023, I've had to issue 7 bench warrants.
I understand this, Your Honor.
That's 7 bench warrants. Those are all not about a phone missing.
They actually were.
Okay, if you want to talk, you go ahead. I gave you your opportunity, but if you want to keep going, keep going.
May I honestly speak, Your Honor?
Ms. Martinez, I think you've spoken. Let's have the judge make its ruling.
I just wanted to say that it was about always with not having a phone and stable housing. And now that I finally have those, I would really like the chance to prove to all of you that I definitely will make it to court. I've made it to court more times than I've missed. I know that, and I will not. Now that I have stable, secure housing, aside from that, I also have 2 jobs I'm looking forward to going back to, and I really don't want to lose this house, because then I will be more dependable than dependent, and I would like to remain that way. And I really know that I messed up that, but I also did think that I filed a warrant recall, though it didn't go through due to bad Wi-Fi, and I really apologize to the court, although I will definitely not be missing another hearing at all, and I know that there will be large consequences if I don't. And I certainly will. I promise. I swear on the Bible and to everyone in my life, on my life.
Mr. Drukas, is she done now?
Yes, Your Honor.
Turn it out to the 20th. I'll grant defendant a PR bond, but that's only effective at September 12th, 2023 at 9 a.m., the day after she's going to enter the pleas in the global resolution, and she can have a PR on this case. Thank you.
Thank you.
The people versus Sari Martin.
Conrad Siller on behalf of Pittsfield Township.
He's here.
Okay. Hello.
Hello. Good morning.
What's your name?
Sarah. It's Sarah.
It's Sarah?
Yes.
Hold on. Is it? Okay. These names today confuse me. So is it Sarai?
Yep. Yep.
But it's
just Sarah.
pronounced Sarah.
Yep.
Okay. I'm just going to let you know now, if I ever have to call it again, I'm going to mess it up. So I'm just going to apologize up front. Okay.
Sounds good.
Right. So you're here. Okay. You were arraigned back on August 16th. Did you wait? Did you not want an attorney to represent you and help you through this, ma'am?
No, not that. No, I did not.
You don't want an attorney?
No, sir.
Okay. So what are you going to do on this?
I was just gonna be honest because I did make a mistake. So
okay, hold on. Hold it. Before you say any more, anything you say can be used against you. I want you to know that, first of all. But you don't have a previous record, right?
No, sir.
Okay.
And
so
given her age, Your Honor, she'd be eligible for a special consideration.
Yeah. So, Ms. Martin, do you know what those special considerations are?
I do not.
So, let's see. Who's going to explain that to you or have you figure that out?
I could ask a parent, but I just wasn't informed.
Seriously? Is your parent a lawyer?
No.
Then how are they going to know?
Probably an attorney.
Yeah. Oh, what a concept. So if you had an attorney, they could probably explain, gee, what kinds of things are available to me so that this doesn't like mess up my life entirely, right?
Yes.
So do your parents know about this charge?
Yes, they do. She was
they're
under
real
the
happy, I bet.
Since
never mind. You don't have to answer that. I'm a parent, so I know how they feel. Not that my kids have, well, never mind. So Sarah with an I, do you want an attorney?
Yes, I would.
There you go. Okay. See? That was a long way for an easy answer. All right. This becomes a public defender case, please.
Good afternoon, Your Honor. Assistant Public Defender Lauren Perry on behalf of Sarah with an I, Martin. I couldn't resist. I'm sorry, Your Honor. I don't even know if we got to a reading in this case.
I'm sorry.
Did we?
She was arraigned on the 16th.
Oh, okay.
And in front of the magistrate, decided she didn't want an attorney because she was going to figure it out herself or ask a parent. I don't know. Call a friend. She was going to do something. And now she wants to have an attorney maybe advise her through the process.
Understood, Your Honor. So
her bond will continue. This now becomes a PD case, and let me adjourn this out. Perfect. So you could explain to her, she says she has no record, so you can explain to her what options might be available. Because she wanted to come here and be real honest. And I don't know what that was all about. But anyway, I'm going to adjourn this. I'm going to adjourn this out to September 20th, 2023, 9 a.m. Or as your Zoom invite indicates. Okay.
Caitlin Kirby on behalf of the people.
Sir, can you unmute?
All right.
Okay, okay, state your name.
Zachariah Haraska Dennis, Your Honor.
All right. Sir, you are before the court on a 2-count misdemeanor complaint. The first charge on that complaint, well, all of this alleges on June 28, 2023, at the location of the Myers store, at 3825 Carpenter Road in Pittsfield Township. The first charge is that of retail fraud in the 3rd degree. Do you understand the nature of that charge, sir?
Yeah, Your Honor, I understand.
You understand that?
Kinda,
Okay, well, let me just say that the complaint says that while Myers was open to the public, that you did steal property from Myers that was valued at less than $200. You understand that charge?
Yeah, I understand now.
Okay. That's a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court cost. The fine could be increased if 3 times the value of the property taken. If that's greater than $200, that number becomes the maximum fine. You understand that, sir?
I do know, Your Honor.
Okay. The second count on the complaint alleges that on that same date and at that same location, that you were a disorderly person because you were drunk. You understand that charge?
I do know.
Okay. That's a misdemeanor, and it's punishable by up to 90 days in jail and a $500 fine plus court cost. You understand that, sir?
Yeah, Your Honor.
Okay. So, sir, the first question that I have for you is, do you wish to be represented by an attorney?
Yeah, I do.
You do? Okay. This is a public defender case.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Haruska Dennis. We will waive any further reading and stand mute to those charges, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. You're obviously going to need an adjournment. Sir, are you held on anything else? Any other charges?
No, I just got out of a court case. They just gave me a PR bond. I was wondering if that's possible. Y'all could maybe run a current or something like that, maybe. I'm not sure how y'all want to do it. My dad, he's a retired veteran. I'm the only one there at this house that lives with them that physically helps him because he
Okay, hold on. So you just got out of another court hearing?
Yeah, just a second ago until I found out I had court with you, Your Honor. And they just gave me PR.
Okay,
That was 15th District, Your Honor. He originally had a $500 bond, but his court date was today. He has a $10,000 bond on a retail fraud 1st degree felony that's up on the 14th. And then he has 2 $5,000 10% bonds out of this court. And the next date is 9/20. He's also on detox currently.
Okay, so he already has cases set for 9/20 that he has bonds on.
Correct.
Okay. Here's what I'm going to do. I'm going to set his bond in this case at a $5,000 10% bond. I'll order standard conditions, including no assaultive behavior, no alcohol, recreational marijuana, or any illegal drugs. He's not to enter any Myers store in the state of Michigan. All right.
And he did a PBT, Your Honor, and it was 0.11.
0.11.
Yes.
All right. And I will also indicate that we'll do a community corrections order for a sober link at this time, but I don't think he's going anywhere anytime soon. All right. And this case will be adjourned with his other cases. I'll adjourn the pretrial to September 20th, 2023 at 9.
So that means that they got us. You want me to sit here in the jail, Your Honor?
Well, I don't want you to, but you will be because you have other cases. Hold on. You have other cases that you have to deal with. Some of them are set before me on the 20th. And then there are other cases that are set on I think at a different date before me.
Well, I mean, I'm trying to, I was hoping you could bless me with one PR this time, cause I promise so I can come back. Cause my dad, I'm the only one physically helping him, that he don't got nobody else helping him, Your Honor.
Okay, sir, hang on. Here's what I'm gonna do. I'm not saying no to that, but I'm not gonna do it right now. So what I want you to do is talk with your attorney. If they can arrange with the prosecutor a way to get you released or some agreement, then I probably won't have a problem with that. But right now, even if I gave you a PR on this case, you're gonna be held because you gotta see me on the other cases.
What do you mean?
Mr. Hurska Dennis, I'll come see you at the jail and we'll go over everything together, okay?
Cause my dad, he won't make it without me, cause he's gonna end up in the hospital, possibly dead if I'm not there helping him physically.
Okay, your attorney will be down to see you. Thank you.
In today's courthouse session, the court first addressed People v. Devin Julia Martinez, where defense counsel reported that a global plea agreement was in progress tied to Martinez's circuit court matters, requesting adjournment until after her September 11th pretrial. The judge granted an adjournment to September 20th, 2023, but the main issue became Martinez's request for a bond modification. Her attorney explained she had stable housing, 2 jobs, and could not afford to lose her sublist. But the prosecutor strongly opposed a PR bond, citing 7 prior bench warrants between 2022 and 2023, and expressing no confidence Martinez would appear. Martinez insisted she now had stability and only missed prior hearings due to a stolen phone and technical issues, pleading emotionally for release. The judge acknowledged her statements but emphasized her history, ultimately granting a PR bond effective only on September 12th, the day after she's expected to enter pleas in circuit court as part of the global deal, meaning she would not be released immediately. The court then moved to People v. Sarah, who originally waived counsel but quickly realized she needed legal representation after the judge warned her about the consequences of speaking on the record. Since Martin had no prior record and qualified for special considerations, the judge appointed the public defender and adjourned her matter to September 20th to give counsel time to advise her properly. Finally, in People v. Hruska Dennis, the defendant faced charges of retail fraud and disorderly intoxication stemming from an incident at Major, alongside multiple existing felony and misdemeanor cases. Although Dennis requested release to care for an elderly veteran he lives with, the prosecutor outlined his extensive bond history including active $10,000 and $5,000 bonds and the PBT reading of 0.11. The judge set a $5,000 bond, ordered no alcohol, no drugs, no assaultive conduct, and a statewide major ban, and added a SoberLink monitoring order because Dennis had other pending matters already scheduled. All cases were aligned to September 20th, 2023, and the judge instructed him to work with his attorney to explore any potential path for future release. For more information, like and subscribe my channel.